Good morning, students. This is your commerce teacher Suresh from Government Degree College, Kukatpalli. Today, we will try to understand the capacity of the parties to contract. That means who are competent to enter into contract. Friends, more often than not, competence and skill are used synonymously, but there is difference between both skill and competency. See, skill is the mere knowledge, whereas competency is referred to legal eligibility. Suppose one medical compounder working in hospital is conversant with the medicines. After working for many years in hospital, he comes to know which medicine cures which disease. So he is skilled enough, but he is not legally eligible. He is not legally competent to give medicines unless he is a qualified doctor. So, competency is referred to eligibility, skill is referred to knowledge. That's the difference between both the terms. Here, we are talking about competency of the parties to form contract. That means legal eligibility to form contract. Section 10 and Section 11 are well settled in Indian Contract Act 1872 to discuss who is competent to form contract. Let us explore that in detail now. So here are the 6 different cases we need to understand with respect to the competency of parties to form contract. 1. He should be a major by age. Who is a major? According to the provisions of Majority Act, Indian Majority Act 1875, one who attains or completes the age of 18 years under normal circumstances is a major, and one who completes the age of 21 years is deemed to be a major when he is brought up under the custody of legal guardian. Remember, under normal circumstances, that his parents are alive, he is brought up by parents, natural parents, then completing 18 years grants the status of majority. But if he is brought up under legal guardianship or loco parents, then age of majority comes into existence only after completion of 21 years of age. Should be of sound mind. That means your mental status should be sound enough to make judgment on the content of agreement or contract. You should not be insane, lunatic, or idiot, that we will see in the next slides. Should not be insolvent. Who is an insolvent? One whose total assets are less than total liabilities and he is formally declared as insolvent. He is not entitled to form any contracts. Should not be a foreign ambassador. Foreign sovereigns or ambassadors often seek diplomatic immunity, so any legal suits instituted against ambassadors are deemed to be the suits instituted against the country which he represents. Therefore, often we bar foreign ambassadors from entering into contracts. We will understand more on that in the coming slides. Should not be a convict. Convict is a person whose guilt is proved and is subjected to imprisonment. Please do remember that there's a difference between mere accused and convict. For the mere reason that you are imprisoned or you are in a jail, you will not become a convict. Sometimes accused can also be put behind the bars. So you must be a convict in order to be barred from entering into a valid contract. Should not be an insolvent. I am sorry, this is retyped again. Should not be an alien enemy. Who is an alien enemy? Alien enemy is the citizen of that country with which our country formally declares a war. So during the war, the citizen of the opposite country shall become an alien enemy. We will examine the status of contracts entered with him before the war in the next slides. Now, first see the question of minor being a party to contract. I told you that minor is not entitled to form any contract. But there are many provisions to be understood before completely barring minor from the vicissitudes of agreements and contracts. So, here are the legal provisions with respect to minor being a party to contract. Well, friends, agreements with minor are void by all means. They are altogether void. Let us take a simple case, a very old case that occurred somewhere in 1895 to understand the position of minor in contract. Mohri Bibi versus Dharamdas Ghosh. In this case, Dharamdas Ghosh, a minor boy, mortgaged along with his mother a property, his house, to borrow some money from money lender. But after some time, he could not repay the money borrowed and the property was about to be auctioned. So, the dispute went on the grounds that Dharamdas Ghosh, the actual owner of the property, was a minor who is not entitled to form any contract. So, court has delivered its judgment stating that minor cannot execute any mortgage agreement. So, the mortgage deed has to be cancelled. Then what about the money he owed to money lender? He need not to pay if he is incompetent. I mean, if he is not in a position to pay, he need not to pay that money. Then what about the house? It should be given back to the actual owner, that is minor. Then what the justice we are doing to the money lender? Nothing. That is the reason why we are telling that agreements with minor are altogether void. So one must be very careful while forming contracts with minor. Minor can always plead minority. So it is a protecting shield to minor. So let us take an example. Suppose a boy fraudulently represents himself to be a major and forms a contract. After some time, he can say that I am a minor, I don't know that it is a fraud to represent my age as major. Yes, he can plead his innocence. So be careful while forming contracts with minors. Agreements of minor cannot be ratified after obtaining the age of majority. Yes, obviously. You cannot say, no, you were a minor back then when the agreement was signed, so you escaped your liability in the agreement. Today you became a major, so you have to enforce that contract. You have to discharge that obligation. Can you say like that? No. So agreements entered with minor cannot be ratified or cannot be enforced for the mere reason that he becomes a major. Rather, a fresh agreement may be instituted when he becomes a major. Parents of the minor cannot be held accountable for his or her promises. So be careful. Hey, your child has come to my shop and borrowed some articles or borrowed some grocery, you have to pay the money to me. You cannot say like that because parents of the minor cannot be held liable for the promises made by the minor. One must be very, very meticulous owing to this reason that even parents cannot be held liable. Minor cannot be convicted except for tort. Yes, if minor is committing a crime, he will be sent to Boston school, but he cannot be convicted, right? Except for tort. Tort means some civil wrong. So except for that, minor cannot be convicted for a criminal offense. We have all witnessed what happened in the national capital some 8 years ago, that a brutal rape case that took place in which a minor was proven to be guilty, but he escaped major penalty or major punishment for the mere reason that he was a minor. Of course, later on, law was amended to punish minors also when they cross the age of 15 years or 16 years, as far as women harassment and rape cases are concerned. That is out of the discussion here, out of the subject here. So you remember that minor cannot be convicted except for tort. Minor cannot be declared as an insolvent. When he is not formally entitled to form any contract, how can anyone declare him as insolvent? So, no court in India can declare minor as an insolvent. Minor can become an agent. Yeah, there is a special contract called contract of agency, wherein it is held that no consideration is required to form contract of agency. Therefore, an agent can be a minor because he is not bound to pay any consideration, nor he is directly held liable to third parties. Rather, the principal who can be held liable. So, agent can be a minor. Therefore, we can say in the reverse word or other words, minor can become an agent. Necessities supplied to minor can be recovered under quasi-contractual obligations. Yes, you recollect Robert versus Gray case from our first chapter, wherein one minor underwent a training for participating in World's Billiard Championship, but he did not pay the training fee to his master. So it was held that providing training comes under supply of necessity. Therefore, it can be recovered under quasi contract, though minor is not competent to form a contract. Right? That is the only silver lining we can find with respect to minor being a party to contract. Minor cannot become a partner in the firm unless the following three conditions are met. Yes, partnership firm is one of the famous business organizations or one of the famous kinds of business organizations we see in India. But law very clearly says that minor cannot become a partner unless the following three conditions are satisfied. What are those? Number one, he should be admitted only to share profits and not losses. What we know in partnership firm, partners do share both profits and losses. But when you admit minor, you must give only profits to him, but not losses. Second, all the partners should agree to admit the minor as a partner. Yes. Suppose there are 4 partners in the firm. We know the rule of majority works. If 3 partners takes a decision, so the 4th partner has to abide by that. But as far as minor being a party to become a partner, all the 4 partners must give their consent. Yes, we do agree to admit minor as a partner. All the partners should agree to admit minor, but not rule of majority. It should be an existing firm. That means it should not be a newly established firm. If you are going to establish a firm and wish to take minor as a partner, it is not acceptable, please. It should be an already existing firm in which minor can be admitted only to share profits, provided all the partners agree to admit him as a partner. Clear? So these are the rules laid down in the law with respect to minor being a party to contract. But 2 important factors you must very carefully remember among all these 9 points is that agreements with minor are altogether void. So be careful while signing any agreement with minor. Second, even the parents of minor cannot be held liable for his promises. So next we'll make a move towards understanding the sound mindness of contract, a party to contract. Well, a person must be of sound mind to form contract. I told you sound mind is mentally fit to make judgment on the content of the agreement. So let us see the 4 important tests or 4 important facets to determine the sound mind. Number 1, lunacy. Lunacy means temporary mental disorder. So one should not be lunatic while entering into contract. So law clearly says lunatic is one who suffers with the intermittent intervals of sound and unsound mindedness. Right? Simply a mental disorder which is a temporary condition. Once he obtains the certificate that he is mentally fit, he is entitled to form contract. But during the temporary mental disorder or during the lunacy, he cannot form any contracts. Idiocy. Who is an idiot? Idiot is not mere scolding, please. Idiocy or idiot is one who suffers with permanent mental disability. So if anyone calls you an idiot, please don't accept that, because idiot is one who suffers with permanent mental disorder. So one suffering with idiocy cannot enter into contract in his lifetime. Third, intoxication. Suppose you are drunk at the time of signing an agreement and you prove in the court that I was drunk at the time of signing agreement, I don't know the content, then you can cancel that contract. Of course, the onus of proof is vested in the hands of one who claims that he was intoxicated at the time of forming the contract. So similarly, opiums, drugs or narcotics, such condition makes you intoxicated. So if you prove in the court that I was intoxicated at the time of agreement and I don't know the content of the agreement, I was of sound mind then you can cancel the contract. I again repeat, the onus of proof is vested in the hands of those who claim that they were intoxicated. Insanity. Insanity means complete illness. Suppose you are suffering with 1 or 2 temperature and having saline to your hands. So you are laid down on a bed. Your friend comes and says, hey, there's a good deal to sell the property. Please give power of attorney to me. So your friend is interested in taking more commission in the sale. So later on, if you prove that you were insane at the time of giving power of attorney to your friend, then you can cancel that power of attorney, or you can even cancel that agreement, not even power of attorney. Of course, power of attorney can be cancelled at any time. But let us take this way. Suppose your friend comes and says, there's a good deal to sell the property at 60 lakhs rupees. Please allow me to sell on your behalf. So you were insane at the time, your health was totally deteriorated and you signed it. So later on you came to know that he sold the property for 75 lakhs. The property actual value is 1 crore rupees. So your friend got benefited out of it. There was some insider agreement between the buyer and your friend. So if you prove that you are insane and there something happened against your benefit, you can cancel that agreement. Right? So here are the 4 different cases we need to understand with respect to lunacy, idiocy, intoxication and insanity. In simple sense, you must not be lunatic, you must not be an idiot, you must not be under the condition of intoxication, and you should not be insane while entering into an agreement. If these conditions are satisfied, then you are deemed to be of sound mind and become competent to form any contract, right? Now let us see the other cases. Other than minor and sound mind, we have 4 other cases. Let us explore that now. So other than minor and unsound mind, you should also remember that one should not be insolvent at the time of entering into contract. Who is an insolvent? I told you already that if your total assets are less than total liabilities, you are insolvent. Does it mean that you can declare yourself as an insolvent? No. It is the court which should declare one as an insolvent. That means either himself or some of his creditors might file a petition in the court to declare him as insolvent. The court will hand over entire property, liquidate it, and give it to the creditors and declare him as insolvent. So once you are declared as an insolvent, you cannot enter into any valid contract. Can he never enter into valid contract? Of course, until he proves his solvency. Suppose my total assets are only 20 lakhs, my total liabilities are 30 lakhs. Then I am declared as an insolvent by the court. So 10 lakhs rupees still I owe to my creditors. In the future time or in the due course of future, if I am in a position to repay the remaining 10 lakhs rupees and obtain solvency certificate from the court, then I will become competent to form contract. So until I clear all the bad debts, I cannot become solvent once I am declared as an insolvent. Simply remember that insolvents are not formally entitled to form any contracts. Should not be a foreign ambassador. Who is a foreign ambassador? A foreign sovereign. I mean, a person who represents entire country on a foreign land. So he often has diplomatic immunity because any legal suits instituted against him will be a spot on the entire country which he represents. Therefore, law often prohibits foreign ambassadors from entering into contract. Suppose a foreign ambassador wishes to enter into contract in India, there are two conditions one must remember. That he must enter into contract only with his Indian agent. There must be one Indian agent through whom he can enter into contract. Second, if any contract is instituted or enforced or has to be enforced with foreign ambassador, there must be special permission from the parliament. The central government must accord special permission to enforce the contracts made with ambassadors. So to keep all these headaches in bay, you please simply avoid forming formal contracts or commercial contracts with foreign ambassadors. Right? Foreign ambassadors are however entitled for social contracts like getting married here or making friendship or such social agreements they are entitled, but not legal agreements or commercial contracts. Should not be a convict. Who is a convict? Convict is one on whom the guilty is proved and he is subjected to imprisonment. Not every prisoner is a convict, please. Sometimes even accused can be a prisoner, but he can enter into contract. There's a difference between accused and convict as far as prisoners are concerned. Suppose one strong politician is suspected to have been involved in a crime. Then an investigation agency may urge the court, may request the court. If he is allowed to go outside, he will tamper the evidence. So please don't grant him bail. Then court may ask him to sit in the jail. The court may direct him to be a prisoner until the investigation process is completed. So he is only an accused, but not a convict. So all prisoners are not convicts, please. Accused person is very much entitled to form contracts, though he is in a prison. But once the guilty is proved and imprisonment is imposed by the court, the prisoner shall become convict. So the convict is not entitled to form any contract during his punishment or imprisonment. Should not be an insolvent. I'm sorry, it is retyped again here. Should not be an alien enemy. Right? Who is an alien enemy? A citizen of that country with which we have a formal war. Right? Suppose there is a war between India and Pakistan. The citizen of Pakistan shall become alien enemy to India and vice versa. You may question, what about the sanctity of agreements which we entered with Pakistani citizen before the war? They shall become void contracts. You remember the definition of void contract or meaning of void contract? At the time of entering into contract, they are valid. But due to some unforeseen circumstances, they may lose validity. They are called void contracts. So, any agreements you made with alien enemy before the declaration of formal war by your country, such agreements shall become void contracts. They are eligible, they are valid at the time of formation, but they become invalid in the due course of declaring a war. Right? Simply you remember that when there is a war between two countries, the citizens of those two countries shall become alien enemies. There cannot be any trade at the cost of blood and flesh of our soldiers. Therefore, law very clearly says that you cannot trade with an alien enemy. An alien enemy is not formally entitled to form any contracts. So with this, our discussion on capacity of the parties to contract is brought to fruition. Right? he must be a major by age, and you also understood the implications of minor being a party to contract. He must be of sound mind. That means one should not be suffering with lunacy, idiocy, insanity, and intoxication at the time of forming the contract. Should not be a convict, should not be a foreign ambassador, should not be an insolvent, and should not be an alien enemy of the country. So these 6 cases you must remember in determining who are competent to form contracts in India. Now let us take assignments. So friends, please attempt these 2 questions. Who are competent to form the contracts? Who are competent to form the contracts? Second, explain the legal provisions with respect to minor being a party to contract. I hope these 2 topics are duly covered in this discussion. We will have a next discussion or next lesson on free consent. Right? So far, if you have any doubts, please feel free to revert back at 98495 60102 or nsureshnaidu@gmail.com. See you in the next class. Have a nice day. Bye.